3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the afternoon session of the Tennessee Court of Appeals. Is there anything we need to address before we begin court?
No, Your Honor.
All right. Please call the case.
Ricky L. Boren et al. Versus Hill Boren PC et al.
The appellant, Ms. Hill, are you arguing?
Yes.
Will you be arguing for the appellant?
Yes, Your Honor.
All right. Did you want to reserve any time for rebuttal?
3.5 minutes.
Okay. All right. You may proceed.
Okay. Thank you, Your Honor. Make sure I'm not on mute. Okay. May it please the court. I'm here today on behalf of T. Robert Hill and Hill Boren PC, separate defendants who are each entitled to justice. The defendants are before this honorable court because the trial court declined to follow Supreme Court precedent in numerous areas. In this instance, plaintiffs do not claim that there's any error in any of the presidential cases cited by Hill or Hill Boren PC. Thus, these precedents should apply to this case. Affirming the verdict and trial court decisions that conflict with precedent would breed uncertainty in contract interpretation, admission of parole evidence, commercial transactions, enforcement of corporate bylaws, standards to find fraud, and fiduciary duty. It would reward plaintiffs for signing a written contractual agreement under false pretenses, promising to abide by its terms, while secretly intending to enforce the conflicting terms of an unwritten agreement. For purposes of oral argument, defendants would like to focus on reasons to reverse, dismiss, and the issues of fraudulent inducement, parole evidence, derivative action, and punitive damages. Dismissal of the entire case is warranted for 5 reasons. 1, defendant's evidence of unclean hands is set out at pages 15, 26, and 30 through 38 of Hill Boren PC's brief. And in page 36 of their response, plaintiffs admit that defendants had, quote, abundant evidence, end quote, of plaintiff's unclean hands, but urge this court to disregard it. Tennessee Rule of Evidence 103 allows this court to consider this evidence because the trial court granted plaintiffs' motion to exclude the same evidence. Under the Hogue case, plaintiffs are barred from any recovery. 2, as per the Hill brief at page 64, the court's party with the jury during trial was not officially memorialized. Thus, there's no unbiased way to determine if the contact was actually harmless, so reversal is required under Spencer. 3, as per the Hill brief at page 67, Boren changed his testimony at trial, averring that the alleged fraud occurred in 2012, yet Boren did not bring his case until 2016. Because his testimony clearly established for the very first time that the 3-year statute of limitations had run, under Red Wing, Hawk, and Eldridge, Boren was required to put on proof to the contrary. 4, for almost 100 years, it has been the rule that where a witness contradicts his own testimony, it is no evidence at all. Plaintiffs, as set out in the Hill brief at page 39, and the Hill Boren PC brief at pages 8, 9, 19, 20, 41, and 53, repeatedly contradicted their own testimony. Thus, their claim should have never been submitted to the jury. 5, relief may be had from an executory contract upon failure of consideration. Plaintiffs now cast the recitals as consideration at page 78 of their brief, yet Boren failed to each of them, declined the offer to stay, as set out in Hill's brief at page 18, and failed to timely complete the condition precedent. Thus, the agreement for future transfer of controlling interest should have never been enforced. Dismissal of certain claims is warranted for 3 reasons. 1, appellees failed to address numerous facts, arguments, and their own admissions, as listed in the reply briefs of Hill on 9 different pages and Hill Boren PC on 14 different pages. And they made multiple allegations unsupported by the record in their response, as documented in the respective reply briefs at Hill pages 6, 8, and 17, and Hill Boren PC pages 7 and 8. Under Tennessee Rule of Appellate Procedure 27, Chioza, and Schaller, these issues and facts and unsupported facts are waived. 2, the November 21, 2016 letters were evidence of settlement negotiations and should have been excluded under Tennessee Rule of Evidence 408. Thus, any inferences arising from them should be disregarded in determining the issues on appeal. 3, the offer of proof and arguments presented are properly before this court under Tennessee Rule of Evidence 103 and Rose, as the offer was presented in the motion for new trial and the arguments were raised at the trial court level as set out in the reply brief at page 20. Dismissal of these specific claims is also warranted. A, fraudulent inducement. Number 1, as per pages 19 and 22 of Hill's reply brief, prior to the hearing on the motion for summary judgment for promissory fraud, Boren speculated on deposition that Hill changed his mind after the agreement was signed, and Boyd affirmatively testified that he was not fraudulently induced. Therefore, under Farmers, the claim should have been dismissed at that point. 2, in the case of executory contracts, waiver of the right to rescission operates as a waiver of the right to maintain an action for damages of fraud. Plaintiffs acknowledge that the agreement for future transfer of controlling interest was an executory contract at page 78 of their response. 3, both Hodge and the Court of Appeals opinion in McNeil require justifiable reliance to maintain an action for fraud in the inducement, and Farmers and McNeil specify that there cannot be justifiable reliance where the alleged promise contradicts the written agreement. Examples are at pages 9 and 10 of Hill's reply. 4, Tennessee Rule of Civil Procedure 9.02 requires particularity in pleading, and plaintiffs failed to comply, as set out at Hill-Boren PC's reply brief at pages 15-16. Instead, they chose to provide unsupported proposed findings of fact and conclusions of law after the trial. Plaintiffs also proved that Hill had kept his promises or that they were not material with respect to allegations actually pled, as set out in Hill-Boren PC's brief at page 20 and Hill's brief at pages 31 and 32. Under the rule and the 2020 Court of Appeals opinion in Alsbrook, the claim must be dismissed. 5, for Hill's brief at page 31, Boren and Boyd each admit that they could have asked Ms. Hill her plans, but chose not to. So to the extent any fraud is based on alleged promises related to Ms. Hill, though such was not pled, it must be dismissed under Roby. 6, specific performance cannot be granted in the presence of fraud for Johnson v. Browder. Plaintiffs asked for specific performance and also claimed fraud. At the end of trial, plaintiffs chose specific performance. Thus, fraud and any associated damages should have been dismissed. Alternatively, if there really was fraud, specific performance should have been denied. B, parole evidence. This is found in the Hill brief at pages 38 through 46 and Hill-Boren PC brief at pages 43 through 49. Because no admissible evidence of fraud was provided at the summary judgment stage, the claim should have been dismissed and parole evidence excluded. The parole evidence rule, clarified by IHS, seeks to prevent fraud by assuming that the parties deliberately chose to put agreements in writing to avoid the uncertainties of oral evidence and determine that admission of such evidence, even without objection, is incompetent and ineffective to alter the term of the writing. The trial court erred in admitting parole evidence over the repeated and ongoing objection of defense counsel. IHS also requires that if a party is unhappy with part of an agreement, he must request a change or refuse to sign it. Despite Boren's admissions that the only change requested was advertising, which he then admitted was immaterial, the trial court allowed him to remake the entire agreement over 4 years after it was signed. C, derivative action and temporary restraining order and injunction. The Hill-Boren PC brief, pages 38 through 43. In 2010, the lead court reminded trial courts that they abuse discretion when they apply an inconsistent standard. This trial court abused its discretion in misapplying McWilliams, Lewis v. Boyd, and Tennessee Rule of Civil Procedure 65 to keep plaintiffs' claims alive and cripple Hill-Boren PC with an improper TRO and injunction. McWilliams is particularly problematic in this instance, as it was decided in early 2019, prior to the trial, and the trial judge below sat as part of the appellate court issuing that opinion. But the trial court erred in failing to dismiss Boren's derivative action in the presence of his express written waiver when Boren's actions met each and every criteria for dismissal set out in McWilliams by the Court of Appeals. D, punitive damages, the Hill brief, pages 35 through 38. Because there was no admissible evidence of fraud in the inducement at the summary judgment stage, the claim should have been dismissed and the award for punitive damages stricken. In addition, in Hodges and per the statute, where punitive damages are allowed, the trial is bifurcated at defendant's request, and evidence must be put on in the second phase to address the Hodges factors. Plaintiffs, despite having the burden of proof, elected not to put on any evidence in the second phase. Thus, there's no basis for the amount of punitive damages awarded. In addition, the court misapplied the law regarding summary judgment under Rye, Boren's duty to disclose under PNC, tolling of the statute of limitations in the presence of Boren's fraud under Red Wing and In re Estate of Davis, corporate bylaw application under Smithart, Lewisburg, and Hall, fiduciary duty of an officer such as Boren not to compete until after resignation under Venture, contract construction in IHS and Pearsall, conditional gift under Sands, and expert qualifications under State v. Scott. The court disregarded the opportunity to correct its own errors as required by Harris, as well as its duty to independently make findings of fact and conclusions of law under Smith v. Lakeside. These arguments are set out in more detail in the briefs and reply briefs of the appellants. In summary, the trial court wrongly eliminated defendants' claims and wrongly allowed plaintiffs' claims to proceed to trial, such that the jury was seduced into believing that Boren had done nothing wrong. Thank you.
Thank you. All right, Ms. Luna, will you be arguing? You're on mute. Okay, we'll hear from the appellee.
Thank you, Your Honor. May it please the court, I'd like to spend my 15 minutes being as helpful as I can to the court and making its decision.
I'm glad you said that because we have some concerns that we need to address with you.
Okay.
There was a motion for remittitor filed in this case, and there was nothing mentioned in the statement of the case by either party about what happened in that to that remittitor. But in looking at the record, we found some documentation that gives us some pause for concern, and I want to get your response to this. On October the 18th of 19 was plaintiff's response to the defendant's motion for remittitor was filed, and in that document or pleading, you raised the constitutionality of the statutory cap on punitive damages, and you point out the Sixth Circuit ruling on the fact that they found the statute unconstitutional, and notice of that pleading was sent to the Tennessee Attorney General. That's the first time the constitutionality was raised, but it was raised in that pleading. And then the court on November the 27th of 19 entered its order on punitive damages and remittitor, and without ruling on the constitutionality of the statutory cap, the court remitted the punitive damages to an amount greater than the cap, awarding $3 million to Boren from $5 million and 1.2 to Boyd from 5 million. Then the court, in addition to doing that, in addition to awarding damages outside the cap without ruling on the constitutionality of the cap, made this statement. Therefore, in the event the Tennessee Supreme Court disagrees with the Sixth Circuit and finds the statute to be constitutional, as an alternative remittitor, the court will reduce the punitive damage award to 2 times the amount of compensatory damages awarded pursuant to TCA 2939-104, which equates to 1.2 million to Boren and 800,000 to Boyd. Then on December the 14th, the court entered an order granting the state of Tennessee motion to intervene, presumably on the constitutionality issue that was raised in your response. Although that issue hasn't been raised on appeal, the Attorney General hasn't been put on notice of the appeal. But the main concern we have is this order of November 25th, where there's an alternative order of damages and no ruling on the constitutionality. We'd like you to explain how we have a final judgment in this case.
Your Honor, the plaintiffs provided a notice to the court after the court issued its order on the punitive damages, the 2 alternative sets of punitive damages that it was ordering. The plaintiffs provided a notice to the court that they were agreeable to the amount of the statutory cap in this case, And so I presume that's why the court did not make the constitutional.
Well, actually, that's not exactly what you did in the notice. Actually, in the notice, you agreed to the statutory cap, and or in the alternative, if that is modified, you asked for the if the Supreme Court were to determine it was unconstitutional, that you agreed. You agreed to two different things, and the order is set out in the alternative, and in the notice of acceptance of the remitter that was filed on December 3rd, you agreed to the remitter of $3 million and $1.2 million, and then said in the November 25 order, the court stated the Sixth Circuit Court of Appeals has found TCA, etc. However, the order suggests an alternative remitter if the Tennessee Supreme Court were to find Section 2939-104 to be constitutional, and then says, in the event the Tennessee Supreme Court were to define 2939-104 to be constitutional, Boren hereby notify the court of its acceptance of the suggested remitter stated in. So there's two separate judgments here, or two separate amounts set out. The court can't retain jurisdiction to do that, and you can't accept both remitters. And then there's an outstanding issue of the ruling on the constitutionality, when subsequent to this order is when the state intervened. We're not clear how you can have an. I've never seen an order like that, and we have concern about how that's a final judgment.
I understand the court's concern. Perhaps the situation may be helpful. I don't know, but we were in the same period of time when the Tennessee Supreme Court was taking that very issue of constitutionality up on appeal and deciding it. So we were facing the order at the same time we were waiting on the opinion from the Tennessee Supreme Court. But I hear what the court is saying as to the finality of the order. The plaintiff's intention was to accept this, if the Tennessee Court of Appeals ruled that the statutory cap was constitutional, to accept that as its ruling, that it would be fine with the amount of the statutory cap of punitive damages.
Well, that may have been your thought at the time and your intention, but that's not the way the order's drafted, and that doesn't answer the question about how this is a final judgment.
Your Honor, I understand what you're saying, and I don't know why the court drafted the order the way that it did, but I understand what the court's saying about the finality.
And do any of the other judges have any questions on this issue? All right, you may go forward with your argument.
Thank you, Your Honor. As you could tell by Mrs. Hill's argument, there are many issues on appeal by Hill and Hill-Boren, almost 50 in total. And by our count, there are only 7 questions that are really appropriately before this court on appeal. The rest of those have been waived. They were waived because the defendants failed to renew their motion for directed verdict at the close of all the proof. They were waived because they left out arguments in the motion for new trial. They were waived because many of these arguments they never made before the trial court. The evidentiary objections that they're making now on appeal, they were not made before the trial court, and there's no proof in the record that those were ever made. They're arguing summary judgment rulings that were denied on the basis of disputed facts. And then the jury eventually got those facts and made the determination on the merits. And now, because they failed to renew their motion for directed verdict, those facts are not properly before this court. On several occasions, the defendants invited the error of the court. For example, on the parole evidence issue that Mrs. Hill addressed, 3 months before the trial, the plaintiffs filed a memorandum of law asking the court to rule on some unresolved legal issues. when the defendants filed their answer to that brief, they said, no, please let these go to the jury on the contract interpretations issues because it needs to be resolved by the jury. AKA, there must be some kind of ambiguity in the contract. They even urged the court to allow the jury to hear parole evidence. And then when we get to trial, they agree that parole evidence is necessary for the promissory fraud claim, but they don't ask for a 105 limiting instruction to instruct the jury that it should be used for one purpose or not the other. They failed to do that. And because they failed to do that, they waived that argument. The statute of limitations and waiver arguments that they now make on appeal, those were waived as they were never pled in any pleading. They were never argued before the trial court until 3 months after the trial was over. They failed, Mr. Hill failed to appeal the unclean hands ruling against him, which precludes this court from looking at any of the issues that have to do with Mr. Hill's counterclaims, because that finding by the jury that Mr. Hill had unclean hands means that he is not allowed to continue within any of his counterclaims. And he did not, as I said, appeal that ruling. There was an abundance of evidence presented to this court that the trial court at the jury trial never saw. And there's no evidence that the trial court ever eliminated all of that, those facts from being heard by the jury. I'd like to go over the 7 issues that are probably the most important because they're the ones that are properly before the court. The first one has to do with specific performance and rescission. And that question that Mrs. Hill brought up just a moment ago is answered by the case of Frizzell versus Gatlinburg. This court decided that case in 1998. A plaintiff who is in the midst of a situation like Boren and Boyd were in the midst of may elect between 2 remedies when he finds out that he has been defrauded. He can either ask for rescission at that particular time, or he can wait and continue to perform his end of the bargain and ask for specific performance and maintain an action for fraud. So he can either ask for rescission or ask for specific performance and maintain an action for fraud. And that's exactly what Boren and Boyd did. The facts of this case are important because in 2012, Boren and Boyd signed the stock transfer agreement with Mr. Hill. Mr. Hill promised them if they would stay for 4.5 years and work for 50% or less of what they brought in, the millions of dollars of fees that they brought in, that Mr. Hill would, at the end of 2016, he would transfer the stock, controlling interest in the stock, to Boren and Boyd. Boren and Boyd stayed. They worked under their employment agreements for 4.5 years faithfully. They get to the end of November, just a few weeks before Mr. Hill was supposed to give them the stock in Hill Boren. And on 11/21 of 2016, Mr. Hill sent letters to Boren and Boyd telling them that dissolution of Hill Boren was imminent. He was terminating their employment as of 12/31 of 16, and he was firing all the employees and that they would not get the stock that they had worked for 4.5 years. So that's why Mr. Boren and Mr. Boyd filed their complaint on December 6th and asked this court asked the trial court for a TRO to stop that December 15th board meeting from going forward and dissolving the corporation. And Mrs. Hill has complained about the TRO that the court entered. But as we've shown in the evidence, Mr. Hill agreed to every aspect of that TRO at the hearing on December the 20th. And that TRO went into effect. And basically what it says is that the status quo would be maintained in this case, pending the resolution of this case. And so as of now, and as of that court's order, the status quo is still in effect in this case. The second issue was whether the trial court drafted its own findings of facts and conclusions of law with regard to the punitive damages. And you can clearly look at what the plaintiffs and what the defendant sent to the judge as proposed orders, and you can see that the judge drafted his own. A third point Mrs. Hill makes is that fraud cannot be based on a promise of future conduct, but the case she quoted was a 1978 case, and since then, the Tennessee Court of Appeals and the Tennessee Supreme Court have adopted a promissory fraud cause of action in Tennessee. Jamarkowicz versus Siddle is the case. They say that they did not have proper notice of the TRO order. Well, Your Honors, that's not true. They were there at the TRO hearing. We provided the notices that were sent to both defendants. I think specifically their complaint was we didn't say why notice didn't have to be given, but because notice was given, there was no reason to say why notice didn't have to be given. Your Honors, I would like for the court to please look at the things that the Hills and Hillborn PC have waived on appeal. When you disregard all of those items which have to do with the facts, this court has no review of the facts of this case because they failed to renew their motion for directed verdict. And I'd ask you to look at Dean versus Home Depot. It's a 1998 case decided by the Court of Appeals, which would give the court the authority to disregard the facts that the Hills have claimed. I thank you very much for your time.
Thank you. Ms. Hill, you have 3.5 minutes. Did you have any thoughts on whether or not we have a final judgment here?
I really don't.
I think you're on mute. Can't hear you. I can't hear you.
How about now?
Yeah, I can hear you now.
Okay. I really don't have anything to add to that, except that I'm not sure that the court is the one that drafted that order, but I can't say that for 100% certain. A couple of things that I would like to address is the fantasy that this started in November of 2016. This started at the latest in March of 2012, when Donna Boren wrote an email to Jeff Boyd that said, stick with Ricky and do whatever your man-panion wants you to do. They both decided not to sign their contracts and didn't tell Mr. Hill. As a matter of fact, Mr. Boren hadn't signed his since 1997. There's a hot documents appendix that's was provided by the court that will show all of this, and that letter is item number 1. This started, and Mr. Boren engaged Mr. Cobb to advise him before he ever signed the agreement for future transfer of controlling interest. And Ms. Hill was part of the recitals, was part of the action steps, as Mr. Cobb calls them, of the agreement for future transfer of controlling interest. And I would ask that the court look specifically at that document because it needs to review that de novo and make its own decision about what that contract says. But it was Mr. Boren who on September 23rd of 2016 sent a letter advising Ms. Hill that once he took over, she would no longer be part of the firm. Though the agreement said that Ms. Hill would be part of the firm going forward after Mr. Hill retired, that Ms. Hill would get stock equal to that of Mr. Boyd. And Ms. Hill also signed this agreement, not just Boren and Boyd. So it started with Mr. Boren backing out of his part of the agreement, such that Mr. Hill had wanted to preserve Hill Boren. He wanted off of the line of credit, and he wanted to preserve a place for his wife in the firm that he founded in 1970. He trusted his friend, Ricky Boren, of 30-something years to live up to his agreement. Mr. Boren did not pay off the line of credit until the court made him. Mr. Boren fired Mr. Hill's wife, and Mr. Boren then left the building and started a new firm and destroyed Hill Boren on the day the injunction, and he admitted at trial, the minute that injunction was issued, Hill Boren was destroyed. The legacy was destroyed. And as far as notice, there was an ex parte TRO that was entered without notice by a sitting judge because the original judge disqualified himself and they did not follow proper procedure in doing that. And Mr. Hill did not agree for them to leave. He never agreed for them to leave. He wanted to do what was best for the clients. And that's all he could do was make things work after they decided to leave.
All right, thank you very much.
Thank you.
We'll get an opinion to you as soon as we can. Thank you so much for your argument today.
Thank you.
This honorable court is now in recess until 2 p.m.